Hello, I'm George from Ireland, carrying on with my English law channel. This is contract law, and I'm looking about the intention to form legal relations. We talked about offer and acceptance already, or rather, I don't want to use the royal we. But this is only a contract if one intends, or both parties rather, intend to make something which is legally binding. Something which is too informal, which is too vague, too unimportant, shan't be a contract. There's no contract about solely social engagements, such as I invite you to a party and then you don't show up. Quite typical for me, because I was going to provide you free food and drink. That was my consideration. And what were you giving me? You were giving me the pleasure of your company or something like that. Or somebody agrees to go and play tennis and then doesn't show up. That's not a contract. That's too trifling. And de minimis non curat lex. The law doesn't care about the smallest things. So courts are not going to adjudicate things which are just exceedingly petty. They don't have time for that. They'd be swapped by trying to deal with all these petty squabbles. So such things aren't justiciable. All right. So if something is forming legal relations, then an outside adjudicator, a court usually, or perhaps an arbitrator, will be able to sit in judgment on it, and therefore it'll be an enforceable contract. So domestic agreements usually don't come within the sphere of a contract. So let me see. So there's Edmonds and Lawson, which is a case about this. And remember, there's the objective standard. What would a reasonable person believe in the situation? Would such a person believe that there was intention to form legally binding relations or not? We're not interested here in the subjective intention, what was in the minds of the parties at the time. I already mentioned President of the Methodist Conference and Preston, 2013, about making somebody a minister of a church, and it was found that under the circs there was no intention to make this a contract. So Balfour and Balfour, 1919, and this is a case of a disagreement between a husband and a wife. The husband, he was working abroad, and he promised his wife he'd give her a set sum of money each month. However, he broke that. Anyway, the court said, well, there's no case to answer here because there was no intention to form legal relations in this particular case. Okay. So it couldn't be adjudicated by a court. There was another case called Jones and Padavatten, 1969, and it's quite similar to Balfour and Balfour. In this case, there was a mother and her grown-up child, so some sort of informal agreement, and no, that was not a contract. You could look at Coward against MIB, where there was a deal. This one man was going to drive the other guy to work, and the one who didn't own the car was going to make a contribution towards the petrol money, but the court said no, that's some sort of private, very informal agreement, and there's no contract there. That other chap would have been driving to work anyway, so no. All right, so we can see that there's a rebuttable presumption that domestic agreements don't give rise to an intention to form legal relations. So remember, it is rebuttable. If there's strong evidence to the contrary, then that presumption can be displaced, and we'll find actually that there is an intention to form legal relations. So we start out with a prejudice towards there not being legal relations, and the onus is upon the claimant to prove that in fact both parties intended there to be legal relations. Prove it to the objective standard, that is, that the man in the Clapham omnibus, were he in such a situation, would assume that this intended to form legal relations. Right, there's merit and merit, for example. In that case, this is between two spouses, but despite it being a familial agreement, it was held by the court that based on the particular circumstances, there was an intention to forge legal relations. You could also look at Drake and Stout in 2003. Here there was a couple, and they made an agreement about welfare payments for the upkeep of the child, and there was the intention to form legally binding relations because there was a very formal letter about that. Anyway, so some consideration was there, and because the mother who had care of the child, she had waived her right to maintenance, only maintenance for the child. So that was consideration on her part, the forbearance or the disbenefit she had agreed to put up with. All right. So the Court of Appeal looked at another case, Salisbury and Salisbury. That's a 2007 case. So there, here, this is between two, an ex-husband and ex-wife. So there was an intention to form legal relations, and partly because consideration was brought, it was very formal. And by the way, if it's between ex-spouses, that's much more likely to have the intention to create legal relations than between current spouses. So one spouse decided that she would give up her right to an alimony in return for receiving something in the will of her ex-husband. So in a lot of these cases, this rebuttable presumption of there being no intention to form legal relations is overthrown if the two divorce. All right. Now we come on to prenuptial agreements. A fairly recent thing in the United Kingdom, Radbach and Garantino in 2010. This went away to the Supreme Court. There was a decision that a husband was not going to get £5.5 million after his divorce because this would not be going by the prenuptial agreement. So the prenup had said that neither of them would gain anything from the marriage financially. There'd be no divorce, right? So anyway, the Lady Hale, the president of the Supreme Court, she disagreed actually, but she was in the minority. Okay, so we'll see this. Look at a case called Simkin and Pays, which is a 1995 case, and when agreements are with non-family members, it's more likely that there will be intention to create legal relations. This was a case about winning a lottery or something like that, and how they're going to divide up the proceeds of that. So three cohabitees, they entered some sort of competition together. They won the money. That was 1955, and how they're going to divvy up the money. Or there was Wilson and Burnett, 2007. This is about bingo winnings, but there was held to be no intention to create legal relations there. I'm not quite sure why. It might be whatever agreement they'd made was too informal or something like that. So let's look at agreements which are commercial in character. So if it's something commercial, the court is going to assume that this intention to forge legal relations is there. There's Athena Brands and Superdrug Stores 2019. There were some emails went back and forth. So the defendant's company employee said that they would buy a certain minimum amount of cosmetics from the claimant company. So there appeared to be a very strong implication here that this was intending to form legal relations. So if you argue that there was no intention to form legal relations, you'd better have some very convincing evidence to demonstrate that. We could also look at Dresdner Kleinwert Limited and a Trill 2013 case. And this was about somebody working for another person. And again, almost without exception, there will be an intention to form legally binding relations. So, however, there could be factual circumstances which prove that there was no intention to form illegally binding relations. Now, when we're talking about selling land, it'll normally say subject to contract, that this isn't a contract just yet. We've agreed this, but it's only a contract when we actually produce a document which says contract on it. So if you have those words, then that will mean we can not presume there to be intention to form legal relations. So because people are very cautious about this, about committing themselves to buying or selling land, it'll be the most expensive thing you'll ever buy. It's something you might only do once in your life. So a courts will be very reluctant to jump the gun. I'm not going to assume that there's an intention to form legal relations when land has been purchased. They need to be absolutely certain that there's this intention. Okay, so sometimes the particular words used in a document will show that there is no intention to form a contract. For example, a comfort letter, Kleinwert Benton Limited and Malaysia Mining Corporation, Berhad, 1989, or indeed an honour clause, such as you'll find in Rose and Frank Company against J.R. Crompton and Brothers Limited, 1925. So Anyway, where two sides are dealing with each other at some distance, the court will probably say that there is an intention to form legally binding relations. So we're dealing with each other as arm's length. That means that they're not family, they're not friends, or it's not inside some sort of corporate system like a parent company. So in cases lately, the courts have often found business people in informal settings have not had an intention to form legal relations. For example, Blue and Ashley 2017. This was a deal about worth £14 million, and there was just an oral agreement which took place in a pub, and that was way too informal. It's got to be on paper. I'm surprised the party said, yeah, well, I did agree to it and did agree this amount, because otherwise it just wouldn't have been provable. But nobody can be held to an agreement worth £14 million in such an informal setting. Okay, so we have regard to the circumstances, as in where they agreed and how they agreed. Same thing happened really in McInnes and Rose, 2017. This was Coulson was the judge there, and they were having dinner and they talked about it at a restaurant, and so later on they exchanged emails and so forth, which showed that they hadn't come to a formal agreement. It was more or less an agreement to agree or to try and agree. Therefore, there was no contract in that case. Okay, so when we have a contract, we must be sure what the terms are. We can't have something which is too imprecise, because when a contract is agreed, usually everything is there. What good or service is being sold and what the price is, often the delivery date or delivery deadline and who's going to pay for the delivery, who the parties are, all that should be crystal clear. Just occasionally there can be some lacunae that can be implied in by courts. So normally a contract just completes that. There's nothing else to be written in. But if we're very unsure what the case is, then there can't be a contract. So look at Scamel and Austin, 1941. The court held that this contract was not enforceable because the terms were just so unclear, and it required another round of negotiations so they could clarify the whole thing. Viscount Morn was the judge there, and he said that the terms were just very indefinite, and therefore there wasn't anything worth calling an agreement. Remember, we need consensus ad idem, agreement to the same. They both agree on on the same. I say it's a ton of gold, you say it's a ton of gold. I say the price is X, and you say the price of X. And I say the delivery date is 31st of January, and you say, yeah, it's the same. If one of us is saying, no, it's the 28th of February, and the other say 31st of January, we're not agreeing to the same. So the reason for this is if we're really unclear what the terms are, then the court can't interpret that because, well, there's no contract there. So the court doesn't want to have to invent the contract, doesn't want to have to put the terms in there any more than absolutely necessary. Otherwise, the court's negotiating. The court is not a party to a contract. It's only to adjudicate an extant contract. So the courts do not want to usurp somebody else's function. Okay, the role of the courts is to uphold contracts which have been made by the parties. The court is not to form the contract for others. So there was Scamel and Dicker as a case about that. Now there's a surprising case where this one's called Durham Tees Valley Airport against BMI Baby 2010. Now the airline was going to operate 2 aircraft from that airport for 10 years, but it didn't say how many flights there were going to be or how many passengers, or I think even which aircraft. But it was perhaps surprisingly that was held to be a contract when it might seem to be just like really unclear. 1 flight a day or 1 flight a year or what? So there might be situations where court parties rely upon an agreement, and then the courts will more likely say, okay, we can infer terms from the situation, if they've already started performing. An instance of that would be Hillas and Arcos 1932. So someone had relied upon the agreement and already started acting on the faith of that agreement, and therefore the court said, well, impliedly they agreed whatever. And that's the normal way they do it in that area of the economy. There's another case a bit like this, RTS Flexible System Limited and Molkeroy Alois Muller Gesellschaft mit beschränkter Haftung and Company, KG. It's a 2010 case. So here it was held that all the important terms had been agreed and the parties had started performing the contract. Went all the way to the Supreme Court and said that they could interpret what the parties intended to do by their actions, by their words, and therefore it was patent that they intended to enter into a contract that was binding upon them, even though some terms had not yet been hammered out. So performance is almost fully carried out. Then the parties show that they believe that they will agree on the terms, even though they hadn't agreed on all the terms. Nevertheless, a contract was found to exist. It's a little bit like British Steel Corporation and Cleveland and Bridge Limited, 1984. Okay, so sometimes the agreement doesn't set out a price, for example, but it has a mechanism whereby the price can be determined. If we'll say, I will pay you whatever, the pound sterling equivalent of $100 on the 30th of August this year. We don't know how much that's going to be, but we can check when the time happens. Or I'll pay you 11% of the profits. We don't know how much the profits are going to be, but we've got a means of finding it out when that actually happens. Okay, so sometimes that they say that a certain term is pointless and it just doesn't mean anything, in which case that term can just be ignored. So they can sever that term and carry on with the rest of the contract. That's Nicolene Limited and Simmons 1953. Just because there's something which is nonsense there doesn't mean we should get rid of a totally otherwise totally sound contract. So now let's look at when agreements are complete. For a contract to be enforceable, there must be a whole contract there. As I said, there could be a very few gaps. If they've already started performing the contract, we'll probably say that's good enough. We can fill in a few gaps. So contract is meant to be everything. There's nothing that they have to agree on later on. So the court might say if something major is missing, like the price or what the service or the good provided is, then we can't have a contract. So there might be some implied terms. You can look at Wells and Devani 2016 about this. I mean, agreement to agree is no contract at all, such as in Courtney and Fairborn Limited against Talani Brothers Hotels Limited 1975. These things sometimes are just not enforceable. For example, you could look at Barbudev and European Cable Management, Bulgaria, EOOD 2012. This was about an investment and it said terms to be agreed. And so the court said, well, that's not a contract at all. Okay, that's maybe something like a memorandum of understanding, it's some sort of communication building towards a contract, but you have not got a contract there. Because if the agreement is not finished, then the court will find itself having to put something in there, having to dream something up, and that's not good enough. If you want a contract, you better be clear what the terms are, right? You better get the other party to agree. We could look at Walford and Miles, 1992. So Lord Ackner was the judge there. He said the parties had negotiated, but their objectives were completely different. And so because their interests were so dissimilar, the court couldn't find there to be an agreement. There was some sort of obligation to carry on negotiating in good faith. Now, an agreement to negotiate, that's not consideration, that's not binding. However, agreements to refrain from negotiation are. Okay, if I promise not to negotiate with another party about selling whatever, that can be part of a contract. That's as per Pitt against PPH Asset Management Limited 1994. Was that almost everything? Yeah, just a few last things. So anyway, keep having to look at case law about this, or indeed the Sale of Goods Act 1979. Anyway, sometimes there's no price in a contract. The buyer must pay a reasonable price. Now, that's a bit tricky, but anyway, sometimes a contract can be held to exist in that case. Sometimes parties have depended upon a contract and behaved in a way that shows they're depending upon it. And so then courts might hold there to be a contract there. For instance, there's Foley and Classic Coaches Limited 1934, or indeed the British Bank for Foreign Trade Limited and Novanex Limited 1949. So the courts say, well, we're going to uphold the contract because the parties placed a reasonable reliance in the same. The other reason is that when parties have relied upon the agreement, then the courts are more likely to imply agreement there, all right, and say that they've got the original, the essential terms. So therefore, we can fill in the few missing terms. Okay, so that's a little bit enough about certainty of terms. Goodbye.